and stuff, and storage everywhere. It's just, oh, it's such a beautiful place. And so I was supposed to tell me to see it reopened and create a drive.
All rise. Hearing, hearing. Court of Appeals for the First District of Texas County Session. Pursuant to adjournment, God save the Constitution and so on forth.
Thank you. Have a seat. Welcome to the First Court of Appeals here in Houston, Texas. I think I really need these. Wait a second. Today we're going to be hearing the case of Mary Lou Lara versus Jimmy Bowie. It's case number 0121-00484-CD. We're going to be having oral argument, and I'll ask first that the parties introduce themselves. But before I do that, I'd like to introduce you to the other members of the court. I'm Gordon Goodman, and on my left is Justice Guerra, and on my right is Justice Hightower. So with that, I'll ask the appellant's lawyer to introduce herself.
Thank you, Your Honor. On behalf of Appellant Mary Lou Lara, my name is Sarah Allen.
Thank you, Ms. Allen. And the appellee's counsel?
Yes, Your Honor. My name is Jeremy Maston. I'll be presenting oral argument. I've also got Kevin Connolly here, who was trial counsel.
Very good. Welcome. Thank you. First, I'll ask you, Ms. Allen, have you thought about whether you want to reserve time to rebut or?
Yes, I would like to reserve 5 minutes, please, sir.
Okay.
Thank you.
So with that, I'll ask you to kick us off.
Thank you, Your Honors. On this appeal, appellant Mary Lou Lara was the defendant in an underlying automobile accident case. On appeal, which we're challenging, are 2 portions of the jury verdict awarded against her. One portion is a part of the past medical expenses awarded in the amount of just over about $20,000 for 2 epidural steroid injections that Mr. Bowie received, commonly known as ESIs. The other portion is the future medical expense award in the amount of $150,000 that was based solely on testimony from Dr. Sparrow, who indicated that Mr. Bowie might need 1 to 3 ESIs per year for a number of years into the future. So all of this is based on
So that would leave in place the award for physical impairment in some portion of the past medical expenses, right?
That is correct.
That's not in dispute in this case.
That is not an issue in this appeal, sir. Yes,
Okay,
sir. That's
yeah.
correct. That's correct. And the reason that we were so specific about the portions of the verdict that we're challenging on appeal is because those portions of the verdict are treatment related to what are diagnosed injuries from Mr. Bowie, diagnosed as disc herniations in his lower back, as well as lumbar radiculopathy, cervicalgia, and lumbalgia. These are all injuries that this court and a number of other courts around the state have identified as being not common or basic injuries, meaning they're not common and basic, they're not within the common knowledge and experience of a layperson to determine causation. As a result, they do require expert testimony to support the causal connection between the accident at issue and the injury and the associated medical treatment.
So can I kind of take us a step down from that and
Please.
ask you, so I understand that Mr. Bowie complained of lower back pain after this motor vehicle accident, and so would it not be in a juror's or layperson's common knowledge that lower back pain would be a possible injury from a motor vehicle accident?
Well, whether generalized lower back pain could be, what I believe is really important to follow is this court's own precedent in cases such as Sanchez versus Leija, where the court found that those types of injuries, because they're not common or basic or understood, these diagnosed injuries, as opposed to just generalized pain. Now, notably, there was not an award of pain and suffering in this case. Had there been, that portion of the jury award would likely not have been challenged on appeal, but it was not there was not an award for pain and suffering. We're talking about the medical expenses specifically. And the prior case law of this court and a number of other courts have held, including the 14th Court of Appeals across the hallway, have held that those types of injuries require expert testimony. And so the only way to say in this case that these injuries didn't require expert testimony would be to contradict the existing case law that has been issued as recently as a few months ago. There's a case out of Dallas, McGee versus Tatum, that was originally in the Houston First Court of Appeals and decided, relying heavily on the Sanchez versus Leija opinion. And it was issued at the end of November, and they once again said these injuries require expert testimony.
Could I ask you, since I was on the panel of the Leija case, could you compare the circumstances in this case with the circumstances in that case, and why you think they are similar?
Certainly. In that case, we had essentially a auto accident, same as in this case. Mr. Sanchez in that case, who was the plaintiff, sought medical treatment several days after the accident, and he went to the ER because his low back was giving him pain. He was treated, released. He later received physical therapy and saw a chiropractor. These are all situations and facts that are aligned in the two cases. Mr. Bowie did not immediately seek medical treatment, did not go by ambulance to the ER, did not see a medical provider for 4 days. He then went to a chiropractor as the first medical provider that he saw and received therapy and some physical therapy and chiropractic treatment. He did so for a couple of months. Then there's a 7-month gap in treatment in Mr. Bowie's record. Similarly, in the Sanchez case, there was a gap in seeking treatment. Now, there is one distinction, although I don't believe that it requires a different outcome in this case. In that case, there were some mental health issues that Mr. Sanchez was complaining about. They're just not at issue here. So to me, that part of his claim is irrelevant to this case. He had also indicated that he had and acknowledged a prior back pain. Again, though, what the case focused on is that the type of injuries for which Sanchez seeks compensation, listing out a number of injuries including ligament sprain, back spasms, lumbar radiculopathy, and then the increased symptoms of post-traumatic stress disorder, are neither common nor basic. And it was his failure to bring forth any expert testimony that led to the conclusion by this court in the opinion that there was legally insufficient evidence to support the award for medical expenses. And the facts are similar in these two cases in that regard.
Since we're talking about causation and expert testimony, what's the effect of the chiropractor's notes that due to clinical exams and diagnostic studies, it is my personal opinion that Mr. Bowie's injuries were the direct result of the accident sustained on 9/2/16. Does that provide any sort of a necessary link via medical records alone?
Well, the issue there, and that is the one sentence that's pointed out in the briefing as being potential expert testimony. The problem, however, is that it's conclusory. And conclusory expert opinions, which basically just say, take my word for it, this, in my opinion, this is the cause, provides no support. It provides no explanation about how or why, what literature was relied upon, what testing was relied upon, any of the information that you would need to make an expert opinion more than conclusory, and a conclusory expert opinion is simply no evidence at all, and it's legally insufficient.
If it had been grounded in terms of in all reasonable medical probability, would that make a difference or not? Or does it require even further explanation just than that type of language in an affidavit or in the records themselves?
I don't believe that would have made a difference, and I think the reason why is that those words, right, the magic words, and all reasonable medical probability, alone don't convert a conclusory opinion into a sufficient one. If that were all it took, I'm sure everyone would write that in every record that they have. However, that doesn't get to the real meat of the matter, which is the how and the why, what observations you made, what testing was conducted, and how that all comes together. There are several cases. There's one, I believe that I printed out a copy, but there was a medical affidavit provided by a doctor. I may need to supplement later with the case site if I find it in the meantime, where he stated, it was several sentences, the affidavit. But again, and it did in fact say, in all reasonable medical probability, it's my opinion that X caused Y. What it failed to do was say why and what that doctor relied on. And so I don't believe that magic language is sufficient to convert what is a conclusory opinion into a sufficient one without the real explanation. And at this case, you know, Dr. Sparrow did come to trial and testify, but she never testified about causation. She never made a causal link. So her appearance at trial is another distinction between this case and some of the cases that we cited, but I don't believe it's a distinction that makes any difference, because even Mr. Bowie appears to agree that she did not testify about causation in the briefing, arguing that it was not necessary for her to do so because his own testimony and his medical records were sufficient.
And she's the doctor that did the ESIs and was going to do the future ESIs that you're complaining about.
She recommended, yeah, the first two ESIs, I believe. I'm not sure if she actually did them. It was her office.
Okay.
I understand that I believe the provider who conducted the ESIs was no longer with the practice at the time of trial and so couldn't testify. But she is the one that opined about the future medical care as well.
Just for the people listening online, ESI means?
Epidural steroid injection.
That's what I thought it meant.
My apologies. I meant to say that at the very beginning. And
I think
I started
you
it.
did say
oh,
that.
okay, thank you. I'm so accustomed to using the
No,
shorthand.
you used the long form and you told us the short form, so you definitely set it up for us.
Okay, thank you. I appreciate it.
Well, thank you very much. And you've reserved 5 minutes for a rebuttal.
Thank you.
So if the appellee's counsel would like to come forward, Mr. Master.
Thank you. May it please the court? So I want to address one of the last things that Ms. Allen said first, which that, you know, maybe my brief was a little inartful. We do not concede that Dr. Sparrow made no causal link. In fact, she said that the pain that she was treating and the pain that necessitated the ESIs was the herniations, was caused by the herniations. And that is in volume 2 of the reporter's record at 229. And when you couple that with Dr. Hines' note that Justice Hightower mentioned a moment ago, Dr. Hines concluded that the herniations were caused by the car accident. So you take Dr. Hines' examination, and in the record, it's in the clerk's record at 41 to 42, and it was also an exhibit that the jury took back in the room with them. There's 25 pages of medical records from Dr. Hines, including all her examinations, all her physical findings, all her, her examinations and her conclusions.
So you're relying then on medical testimony as opposed to lay testimony? I mean, you're relying that the medical testimony is sufficient?
Yes, Your Honor.
Okay.
It's our position that you take Dr. Hines' testimony plus Dr. Sparrow's testimony. Dr. Hines connects the accident to the injury, and Dr. Sparrow connects the treatment of the injury to the future medical expenses and the past medical expenses. Now, we also have some distinctions in this case
May
from...
I ask a clarifying question? So, I'm fairly certain that in your brief, you talked about this type of injury being something that laypersons could understand. And so you're not saying that anymore?
Well, Your Honor, as I said a moment ago, it may have been inartfully briefed. It is our position that, as you said a moment ago, car accident connected to lower back pain, a jury can figure that out. I mean, it is similar, in that respect, it's similar to the Hills case where the woman had her ankle up on the dashboard, she gets into the car accident and breaks her ankle. You don't need a doctor to testify that the car accident caused the ankle. But the specific issue of how do you treat that lower back pain, I think you do need the medical testimony on that, which we got from Dr. Sparrow, and who said that to address this kind of pain, you've got to do the ESIs. They're not a permanent fix, and he's probably going to have to do them for the rest of his life. And so,
Let me ask a question about that. So, as to future medical, Dr. Sparrow testified that Mr. Bowie, is that right, Bowie?
Bowie. Yes,
Bowie could possibly need 1 to 3 injections per year if his pain comes back and is increased, and it could be until he's 60 or 70. Isn't law pretty well established that there has to be a probability or a reasonable medical probability as opposed to possibly if and could be?
Yes, Your Honor. And that question and answer by itself probably wouldn't get us there. But if you take the rest of her testimony, as well as Mr. Bowie's testimony about the pain that he is in, the pain that he is experiencing, and then I would also point out that the jury didn't award him 50 years worth of ESI injections. They only awarded him about 5 years worth. So you put those together, and I think that gets us past that hurdle. Now, in the Sanchez versus Leja case that we were discussing a moment ago, I think there is one very important distinction between this case and that case. In the Sanchez case, the plaintiff there testified that he had a prior back injury. So what he was asking the jury to do without expert help was to pick between the prior back injury and the injury from that particular car accident, which one caused the damages he was seeking to recover. That's different from this case, where Mr. Bowie testified that before the accident, he'd never had any back pain, he never had any herniations, he has the accident, and then he has the back pain. There was no evidence of any other causation.
But he did testify that he had been involved in a prior motor vehicle accident, isn't that right?
He did, but unlike Sanchez, where the plaintiff in Sanchez testified about a prior back injury, Mr. Bowie testified that he had not had any disc herniations before or had any back pain before this accident.
Where does the sufficient length, though, come? I mean, I've read all of these 3 cases. Where does you can't see a herniated disc as a layman, and you're getting ESIs for this type of disc abnormality treatment. So I read these 3 cases, and it seems that's going to require expert testimony as a specific causal link to be able to establish the damages arising therefrom. What exactly is getting this link that seems to be required by the Supreme Court cases and cases from the 1st and 14th and other cases?
Well, Your Honor, in this case, we have the medical testimony from Dr. Hine, who says the car accident caused the disc herniations. And it's not just one sentence, it's 25 pages of medical records, and that is itself one sentence, but it is the sentence at the end of a 2-page examination where she goes through all his systems, the history of present illness, as well as her prior relationship with him, her examinations of him. So that evidence bridges the causal link between the accident and the injury, the disc herniation. The bridge between the disc herniation and the past and future medical expenses came from Dr. Sparrow, who said that the pain that she was treating and that the ESIs would treat came from the disc herniations and would required ESIs in the past and would require ESIs into the future. Now, I do want to point out that, you know, there's some discussion about, you know, what is a conclusory opinion. And the Davis case out of this Court of Appeals back in 2000 dealt with the situation of the case wasn't totally analogous to this, but it had to do with whether a physician's opinion was conclusory. And in that case, the doctor was the plaintiff's treating physician, as well as he had reviewed the records. And so he said that his opinions were based on his treatment of the individual as well as his review of the records. In this case, Dr. Sparrow was one of Mr. Bowie's treating physicians, and she testified that she had reviewed all his records and that her opinions about the necessity for ESIs into the future were based on that review as well as her experience and training and the literature.
So what's your best case to zip all this up and connect all the dots for causation?
I'm sorry, Your Honor.
The best cited case. What's your best case or cases that support this argument that you're making that cobbling together all of, you know, the medical records, the testimony is enough? Because now we're off of the layperson's understanding. We're into now the expert testimony. You seem to concede now was required. And so what's your best case to show that there's been cases where you've had to cobble together these opinions?
Well, Your Honor, I think that happens in every case, because you couldn't have you know, one physician testify to every issue in the case. You have to cobble together expert opinions in every case. Dr. Sparrow wasn't there in the beginning. She couldn't testify, you know, about her examination right after the accident. She had to rely on Dr. Hines' reports and Dr. Hines' opinions. And so I think this case falls right in with Guevara and Hills and all the other cases. It just leads to a different conclusion because the facts are different. It's the same rule, it's just different facts. Now, one thing I do want to emphasize is that in this case, there was no evidence of any other cause. So, you know, this isn't a situation where a jury is trying to figure out which of several different causes led to the future medical expenses. There was only one cause, and it was the accident. And so, you know, I don't think that we had to have Dr. Sparrow specifically say, I don't think she had to draw those connections. I don't think she had to say the car accident caused the herniation, led to the future treatment. She could rely on Dr. Hine and her records that she reviewed. Now,
Can you point me to a case like that, where you have the testifying expert relying on the records from another?
I don't have a case at my fingertips, but I would gladly supplement with a case along those lines.
Do you understand what I'm asking for? Is something more analogous to your situation, where you have the exact same situation, where you have someone who reviewed someone else's records, then testifying about what they believe will happen in the future?
I understand, Your Honor, and I can, as I said, will gladly supplement with a case or two along those lines. I do know from my own personal experience trying cases that experts rely on each other all the time. Maybe not in every case, but it's, as long as it's the kind of thing that they can rely on, then they can build their opinions on another expert's opinion. And which is what Dr. Sparrow did here. She reviewed those records. She knew that he had disc herniations, and that in all medical probability, the ESIs were medically necessary to treat those disc herniations on into the future.
Did the chiropractor ever rest their opinions based on a reasonable medical probability?
Your Honor, I don't know if they ever phrased it that way, but they did. I mean, there were. In full candor, Your Honor, I don't know if she phrased it that way, but it was based on 2 months worth of treatment, 2 months worth of visiting, and all the examinations that go into that. And she didn't. I would point out she didn't say that there were any other possible causes, and there's no evidence of any other possible causes. And so, I wish I had a better answer for you, but that's the best I have, Your Honor.
That's what it is.
And so, along those lines, I mean, this is a straightforward causation case where perhaps the experts could have used magic words and made it a really easy case. Unfortunately, they didn't. But we had a guy who didn't have any back pain before he gets in a car accident, has the accident, has the back pain. We have an expert who says it was caused by the car accident, and an expert who says the way to treat that pain is the 2 ESIs in the past and ESIs on into the future. And so I think this falls into what Guevara talked about, where there's a really clear line between the occurrence and the condition. And even if a layperson can't tell the difference between, a herniation and radiculopathy, we have the experts who did talk about that and made that causal link. And so, unless there are any other questions, I'll yield the balance of my time.
Well, so can you further distinguish the McGee case, the Dallas case that was referred to, McGee versus Tatum?
I apologize, Your Honor. I'm blanking on that case right now.
Okay, so it's the case that Appellant's counsel referred to, and it's a case out of the Dallas Court of Appeals. I can give you the site. So I have the Westlaw site. It's 2022 Westlaw 172-48174, and it applies the Sanchez versus Leija reasoning, and wanted to see if you could distinguish that case, because it's really relying on this court's precedent.
I apologize that I'm not prepared at the moment to do that, but I will supplement to address it. I would point out that a major difference between this case, I can tell you, as I said a minute ago, the Leija case, the difference there is the guy admitted he had a prior back injury, and so the jury had to pick which back injury. And in the Hills case, what the opinion says is that there were just medical bills. What we have here are not just medical bills, although we have those. We have all the medical records setting forth their examinations and what they saw in their findings, and then the conclusions on top of that. So I think those are two big differences between this case and both Hills and Leija.
Thank you, Mr. Master.
Thank you.
Ms. Allen, did you want to rebut?
If I please the court. There are a few specific issues I would like to address immediately. The Hills v. Donis case, one thing I think is important there is that in fact they did have medical records in evidence in that case, so it was not solely invoices. And I think that's an important distinction because these medical records are going to be consistent. But
Did Hills have also a testifying expert who relied on those medical records?
No, ma'am. No, ma'am. There was no testifying expert at trial in that case. One thing that I think is notable about that case, though, is that upon they substituted a second opinion, and when at that point in time they found that 2 of the 5 plaintiffs had some medical expenses that did have factual and legally sufficient evidence to support them. The 3 of the 5 that did not complained of the same types of injuries we're talking about in this case, namely, various lower back, thoracic, cervical displacement, discogenic pain, disc herniation, radiculitis, and lumbalgia. So the same types of injuries. And those are the injuries that the court in the 14th Court of Appeals in that case said, these are not common or basic, they require expert testimony, and there was nothing in the records to support that. Now, one of the things that they talked about is that the records had various references, including there was a letter written from one of the doctors in the record, but the court determined that that was no evidence at all, because the opinion did not rest in reasonable medical probability, and it was a bare proclamation that this one event caused another event. The case I was referring to previously when I was talking about the type of bare conclusory testimony that is insufficient is another case that I wanted to quote from the 14th Court of Appeals from 1999. This is Bland versus Ali. The site on that case is 7 Southwest 3rd, 741. There was, in fact, an affidavit in that case. And the doctor in that case said, by their negligent acts and omissions, this was a med mal case, said, by their negligent acts and omissions, Doctors Ali and Bartassis allowed Mr. Bland's condition to deteriorate. Prompt recognition and treatment of Mr. Bland's condition would have led to appropriate treatment of his condition, and more likely than not had led to an improved outcome for Mr. Bland. It is further my opinion that Drs. Ali and Bartassis' negligence was a proximate cause of Mr. Bland's injuries. So we have a lot more substance here. Again, conclusory, no evidence at all. I think there's a similar type of testimony that was discussed. Well, I'll have to come back to that point. I apologize. Oh, yes, in the Guevara versus Ferrer opinion, which all of these other opinions cite back to, which is the Texas Supreme Court opinion. I believe what's really important to revisit is that the fact that in order for non-expert evidence of causation to be sufficient, you have to have a basic physical condition that is within the common knowledge and experience of laypersons. And I just wanted to accent that because I believe if there's any question about whether or not this case required causal connection, expert testimony creating the causal connection between the accident itself and the injuries, I believe that the cases make it very clear that it was absolutely required. So that leaves us with the issue of cobbling together this testimony. Is that sufficient? I think we can deal with that pretty handily by saying, first and foremost, that the one line that was pointed out in the medical records from the chiropractor, Dr. Hun, I may be mispronouncing that and I apologize, meets the definition of a very bare proclamation that X caused Y without any explanation. When that is the case, that is no evidence at all. So you can't cobble together no evidence with something else and get to legal sufficiency.
What about the argument that it was a lengthy narrative, and even though we're focusing on that one sentence, that there was text before that that would be sufficient?
Certainly. Well, there's a couple things. In the records, if you go through all the records, and obviously we don't have time to talk about all of them, but in a number of the records, you're going to have history sections. There'll be references to MVAs, which is short for moving vehicle accident, right? That is always information that is taken down by the provider from the patient themselves. And so it doesn't convert itself into expert testimony simply by the fact that the provider noted the complaints and the statements of the injured patient. And this is consistent with an opinion, Justice Goodman, that you wrote in Hunter versus Texas Farm Bureau Mutual Insurance Company. This was a December 2nd, 2021 opinion, 639 Southwest 3rd, 251. I believe it was a UIM case, but the issue with regard to the sufficiency of the expert testimony when reviewing the medical records specifically is that, a number of these references, it's just information coming from the patient. And then with regard to basic statements, unless you have an explanation, it's not up to the jury to say, oh, well, there's this test that is the, Planter's whatever test for radiating pain. to see that it says flexion, normal, blah, 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 and then be able to say, oh, that means that this conclusion makes sense over here. You have to have the provider, the expert, provide that logical conclusion and that causal connection. And here we simply do not have it. Thank you, Your Honors. Appreciate your time.
Thank you, Ms. Allen.
And if there are no further questions, I'll yield back the remainder of my time.
I don't think you have it.
You have no time left.
Oh, I've gone over. Okay.
That's all
Well,
right.
I'm
Just
sorry.
a little bit, just a little bit. All right, well, I want to thank all the counsel for very fine arguments in this case, and these are hard issues, but we're going to consider them carefully. With that, the case of Mary Lou Lara versus Jimmy Bowie, case number 0121-00484CB, has been submitted to our court. And thank you very much.
Thank you.
All rise.